Welcome to today's webinar on the recent workers' compensation legislative amendments. My name is Jane Stevens and I will be moderating this morning's session. Today's webinar will offer you the opportunity to interact with our speakers. You can submit your questions in the question box on the right-hand side of your screen. We will have a dedicated question time at the end of the webinar, but you can submit your question anytime during the session. We will do our best to answer as many questions as possible. If we don't have enough time, we will provide answers to frequently asked questions on our website. I would now like to welcome our guest speakers, John Kinnane and Amita Laroiya, who are both senior lawyers at WorkCover Queensland. I will now hand over to John.
Good morning, everyone, and thanks for dialing in this morning. Today's webinar will explain the recent legislative amendments in the Workers' Compensation and Rehabilitation and Other Legislation Amendment Act 2019. Essentially, these changes provide for enhanced psychological support, insurer discretion to waive time limit if a worker is certified with an incapacity, rehabilitation and return to work, access to accredited programs, rehabilitation and return to work coordinator qualifications, courses and access to accredited programs, requirement for self-insured employers to report injuries and payments to their insurer, apologies and expressions of regret are exempt from consideration in common law claims, workers' compensation scheme coverage for unpaid interns and other administrative changes. Now, today we're talking about what those specific amendments to the Act are. We are not intending to provide any advice in relation to how these amendments are to be specifically interpreted or specific advice relating to your business. On the 22nd of October, the Workers' Compensation, Rehabilitation and Other Legislation Amendment Bill 2019 was passed by the Queensland Parliament and received assent on the 30th of October 2019. Some of the amendments are effective from the 30th of October 2019 and some are effective from the 1st of July 2020. The new legislation amends the Workers' Compensation and Rehabilitation Act 2003 by enhancing workers' compensation claims experience for injured workers and providing more support for vulnerable workers, particularly those with psychological injuries, to recover from their injury, rehabilitate and return to work. So the first amendment that we will be discussing are the changes in relation to psychological claims and also the support for workers with psychiatric and psychological injuries. So the meaning of injury under Section 32 has been amended to now have a definition of psychological injuries to be consistent with that of the physical injuries. So previously, to have a psychiatric injury, your employment had to be the major contributing factor. Now it has been amended to a significant contributing factor, which is consistent with all injuries across the legislation. And that amendment is effective from the 30th of October 2019. Support for workers with psychiatric or psychological injuries are two new sections in the Act under sections 232, capital A, and 232, capital A and B. Now, WorkCover will now take all reasonable steps to provide reasonable support services to workers suffering from psychological injuries before their workers' compensation claim is decided, to assist in reducing the severity, duration and recurrence of mental illness. So, with respect to these types of services, we are able to support workers earlier by coordinating access to certain types of psychological support services while the application is assessed. The available options will be discussed by the claim owner during the initial conversation with the injured worker. In addition, at registration, an automatic SMS email to the worker is sent to advise we can facilitate early access to support services, including a website link where they can find out more. Compliance will be monitored by the regulator and penalties may be imposed on WorkCover if those requirements are not met. So the types of support services that we can offer are general practitioner appointments, counselling or psychological sessions, psychiatric appointments, psychotropic medication, mediation services, and generally costs associated with hospital emergency department treatment as outpatient only. There is no provision for any inpatient services. Now, it's important for employers to note that there will be no premium impact if the claim is not accepted. Our experience in dealing with psychological and psychiatric claims tells us that the earlier that we provide workers with support, the more positive experience they have, regardless of the outcome of the claim. WorkCover has some experience with our small business customers where we have had very positive engagement and recovery outcomes in relation to very similar services that we've provided as part of that pilot. Now, the next amendment we'd like to talk about are changes to section 131 in relation to the time for a lodgement of application. Discretion is now allowed to accept claims lodged outside the 6-month legislative timeframe to ensure workers who attempt to manage their injury at work are not disadvantaged. This amendment will apply from the 30th of October 2019. So for any injury from the 30th of October 2019 onwards, the time to apply may be waived if a person is subsequently assessed with an initial or total or partial incapacity 6 months after the original injury has occurred. Now, section 131 has always contained provisions which have allowed waiver of the 6-month time frame, which include absence from Queensland, mistake, and a reasonable cause. The new amendments allow WorkCover to and state may waive the 6-month time frame to apply for a particular application if it is satisfied that a doctor, nurse practitioner, or dentist has assessed the injury as resulting in total or partial incapacity for work, and the customer lodged the application within 20 business days after the first assessment under paragraph A. Now, it's important to note that this amendment was introduced to temper the industrial court decision in Blackwood v. Toward. In that case, it was determined by the industrial court that the 6-month time limit began on the date the doctor assessed the worker as having a work-related injury, even if at that point there is no incapacity for work. So, for example, a medical expenses only type claim. The explanatory notes advise that the intention of this amendment is to assist stoic workers with chronic or insidious or psychiatric injuries who attempt to manage their injury at work before potentially deteriorating, and that when they do not lodge the claim at the time when they are first assessed, but a later time when they become incapacitated for work. A simple example in relation to how these provisions may apply is if a worker sustains a back injury at work on the 16th of December 2018. The worker went to the doctor at the time and was essentially advised to take some anti-inflammatory medication but continued to work. The back condition gradually became worse over time to the point that the injured worker goes back to the doctor on the 7th of November 2019 and is determined that he is partially incapacitated for work and needs to work less hours as a result of the injury on the 16th of December 2018. If the worker lodges the capacity certificate within 20 days from the examination on the 7th of November 2019, WorkCover may waive the 6-month time limit and consider the claim and whether the person is a worker and has sustained an injury. Now, I'll hand over to Amita to talk about the return to work amendments.
Thanks, John, and good morning, everyone. So one of the significant changes that have been made to the Act has been with respect to rehabilitation and return to work programs for insurers. Whilst all insurers have had accredited return to work programs in place, the access to these accredited programs has only been mandated for workers who have lodged a notice of claim for damages. As a result, many workers have fallen through the gaps or have had their rehabilitation and return to work progress stalled when they may have otherwise benefited from having access to an accredited program during or at the end of their statutory claim. This in turn limits the achievement of a durable and meaningful return to work outcome. These new return to work amendments were introduced to fill in that gap by providing rehabilitation services between the end of the statutory claim and the commencement of a damages claim. These amendments to Section 220 of the Act came into effect on 30th of October 2019. Section 221 provides that insurers' responsibility must take all reasonable steps to secure the rehabilitation and return to work of workers who have had an entitlement to compensation and workers who are participating in an accredited rehabilitation and return to work program of the insurer. Section 222A provides an insurer may refer a worker who is receiving compensation for an injury to an accredited rehabilitation and return to work program of the insurer. The insurers will continue to have the ability to refer a worker to an accredited program at any early stage of the claim process, and there will be no changes in responsibilities in relation to treatment, care and support needs for the workers with serious personal injuries. Section 222B is a mandatory provision and requires an insurer must refer a worker who is receiving compensation for an injury and has asked the insurer to be referred to an accredited program. Provision 222C requires an insurer must also refer a worker who has stopped receiving compensation for an injury and has not returned to work because of the injury to an accredited rehabilitation and return to work program. It is of significant note that this provision is now a penalty provision. It is an offence for an insurer to fail to fulfil its obligations and secure the rehabilitation and early return to suitable duties of an injured worker. Maximum penalty an insurer may incur is 50 penalty points, which currently equates to a maximum monetary amount of $6,672. There are instances where an insurer does not have to refer a worker to an accredited rehabilitation or return to work program, and this is set out in Section 223 of the Act. In making any assessment, the insurer needs to demonstrate it has taken all reasonable steps to secure the rehabilitation and return to work of an injured worker. Section 223 applies when an assessment is being made to refer a worker to an accredited program. This provision sets out the instances where the insurer does not consider it reasonable to refer a worker to an accredited program. This would be where the insurer is satisfied that the program cannot further assist the worker with rehabilitation for the injury, or where the worker is already participating in an accredited program. An example of the latter is where a worker has had two claims and the first one was closed, which resulted in a referral to the program. When the second claim closed with no return to work outcome, the insurer would not need to re-refer. Again, the key piece under these amendments is for an insurer to clearly demonstrate that it has exercised reasonableness in making the assessment. Section 224 of the Act sets out the instances where a worker's entitlement to participate in the program will cease. Section 224 outlines a worker's entitlement to remain in the accredited program continues until the worker is unwilling or unable to participate in the program is not able to further assist the worker receives a payment of damages for the injury, the worker receives a redemption payment for the injury, or the worker receives compensation for the injury for 5 years. Any decisions will be reviewable decisions under the Act. Again, this comes down to a question of the insurer demonstrating that it is reasonably satisfied that the entitlement to remain in the program should cease. From 30 October 2019, an insurer must take all reasonable steps to coordinate the development and maintenance of a rehabilitation and return to work plan for workers who have sustained an injury. This is a new requirement that's set out under this section in Section 225 of the Act. The written plan is to outline the rehabilitation objectives for the worker and the steps required to achieve the objectives. This is developed in consultation with the worker's employer, and the registered persons treating the worker. Effective from 30 October 2019, the amendments to Section 228 create a new obligation on employers to take all reasonable steps to assist or provide the worker with rehabilitation, to ensure the rehabilitation is of a suitable standard as prescribed by regulation, and to cooperate with the insurer to enable the insurer meets its obligations for rehabilitation. The employer's obligation for rehabilitation has now been extended such that it starts on the day the worker is injured and does not cease until the insurer's responsibility for rehabilitation ceases under Section 220. This means that the employer's obligation for rehabilitation continues even if the employment arrangement with the injured worker has ceased. The new obligation also requires all employers, regardless of how they are insured, to give their insurer written evidence if the employer considers it is not practicable to provide the worker with suitable duties. The worker's employment status is not a reason for an employer to not provide the worker with suitable duties. Similar to Section 220, this provision is also a penalty provision. Another change that has been made to the Act has been the introduction of Chapter 5, Part 14 of the Act with respect to expressions of regret and apologies. This came into effect from 30 October 2019. Despite numerous positive outcomes for both workers and employers, if an employer offers a sincere apology to a worker following a workplace injury, many employers are hesitant to apologise to workers, fearing that it will be interpreted as an admission of liability. Under the Civil Liability Act 2003, apologies regarding other personal injury matters in Queensland are able to be provided without prejudice. That is, they have no liability consequences. Chapter 5, Part 14 of this Act attempt to bring the legislation in line with the Civil Liabilities Act to exempt expressions of regret and apologies provided by an employer representative following a workplace injury from being considered in any assessment of liability in a civil action brought under the Act, specifically a common law claim for damages under Chapter 5 of the Act. Under the legislation, Section 320C defines an expression of regret made by an individual in relation to an incident alleged to give rise to an action for damages is any oral or written statement expressing regret for the incident to the extent that it does not contain an admission of liability on the part of the individual or someone else. The benefits of the exemption are to be less adversarial to the resolution of claims and to improve the relationship between the workers and the employers early. The change also addresses feedback from workers and employers that was gathered during research in relation to this provision. Any expression of regret or apology made prior to 30th of October 2019 will be inadmissible if a relevant notice of claim for damages is made after 30th of October 2019. I'll now hand back to John.
Thanks, Amita. Now we'll be talking about some of the amendments that are effective from the 1st of July 2020. So no changes have been made to the employer's obligation to appoint a rehabilitation return to work coordinator. However, the obligation has been extended to require the employer to provide details of the coordinator to its insurer. Name and contact details, workplaces that the person has a responsibility for, and the statement of their qualifications will need to be supplied. Employers must provide these details to the insurer within 12 months of the coordinator's appointment and updated within 12 months of any change to the details. There are also regulator-approved training courses available for employers to demonstrate that their rehabilitation and return to work coordinators are appropriately qualified. We will collect this information from employers as part of the premium renewal process each year, and we will collect it for the first time at the commencement of the next financial year from the 1st of July 2020. We'll now talk about the next amendment effective from the 1st of July, which is the coverage of unpaid interns. So from the 1st of July 2020, workers' compensation coverage will be extended to unpaid interns to ensure these individuals have access to entitlements in the event of an injury. An intern is defined in the Act as being a person who is performing work for a business or undertaking without payment of wages to gain practical experience in the type of work performed by the business or undertaking, or to seek to obtain qualification, and would be a worker if the work performed by the person were for payment of wages. It also clarifies who is not an unpaid intern, and that is clearly a paid intern, a volunteer with a not-for-profit, religious or charitable organisation, a student on work experience or vocational training, or a person giving unpaid assistance as a favour. We're currently investigating options for how premium will be calculated for any unpaid interns that you may engage. We're covering off some requirements for self-insurer employers as well, and there has been some changes to their reporting obligations. Previously, there was an exemption for self-insurers in reporting injuries and payments made to workers and the requirement to pay excess. Those provisions have been removed. The self-insured employers will now be required to report injuries, payments made to workers to their insurer, including the requirement to notify their insurer of any excesses paid, and to align current requirements imposed. And the reason for this change was to align the current requirements imposed on all other employers within the scheme. Now I'll hand back to Amita to talk about other miscellaneous changes.
Yeah, thanks, John. So other miscellaneous changes made by the Act that came into effect from 30th of October 2019 are applying for compensation, the review of compensation, and life expectancy to qualify for terminal condition lump sum. So with regards to application for compensation, Section 132 of the Act requires strict compliance with the approved form or certificate is not necessary, and substantial compliance is sufficient. An insurer cannot require an injured worker to submit any further evidence or particulars unless it is prescribed by the regulation. With regards to review of compensation, Section 168 has been replaced with a new provision prescribing when an insurer may conduct a review of compensation. An insurer may review the person's entitlement to compensation under the Act only if the insurer considers a person's entitlement to compensation under this Act may have changed. This would require the insurer to have evidence to support the consideration prior to commencing the review. With regards to life expectancy to qualify for terminal condition lump sum, the meaning of terminal condition has changed from a condition that would terminate a worker's life within 2 years of the condition being diagnosed to a worker has to be certified by a doctor that their work-related injury is expected to end their life, regardless of the time frame. This applies to all injuries that have been sustained on or after 31st of January 2015.
Okay, thank you. We'll now move to questions. We've had a number of questions come through during the webinar. So I'll hand over to John and Amita to provide as many answers as we possibly can within the time period. Thank you.
Okay, thank you, Jane. One of the first questions we've received is the 30th of October 2019. Does that refer to the date of the application or the date of injury or the date first seen in relation to a psychiatric claim? It refers to the date that the person, and it will be considered from the date the person is first diagnosed with that condition. So any diagnosis from the 30th of October onwards, those new site provisions will apply under Section 32, and also the requirement to provide assistance. It's important to note in relation to Section 32, that is the only amendment the provisions in relation to exclusions for reasonable management action under section 32.5 remain. Our experience over time from 2013, when the definition of injury changed to the major contributing factor for psychiatric injuries, our experience was it never really changed the ability for us to make decisions of not allowing compensation. Essentially, we weren't able to obtain evidence which really sustained those types of decisions. So we don't anticipate that there being many changes in relation to how section 32 has now been aligned with a consistent definition of injury for physical and psychiatric injuries. Another question is, who pays for the psychiatric treatment or the care and services provided in the period of time between a psychiatric or psychological injury claim being lodged and the claim being accepted? If that claim is not accepted, more to the point, who pays for those treatment? Who pays for that treatment? That would be the Workers' Compensation Fund. So it's not something that would be offset against an employer's premium if the claim is denied. I should say. Another question is, are there any change? Are the legislative changes retrospective? In the main, all of those provisions are not retrospective. There is a provision under the terminal condition provisions which are applicable from the 30th of October 2019, I apologise. It applies to some claims that have been lodged beforehand. So there is, I suppose, if you like, a small retrospective component to those, but all the other provisions are in force from when they come from assent. So that is 30th of October or from the 1st of July 2020. Another question is, will unpaid interns be premium impacting should an injury occur? The answer to that would be, once WorkCover has determined how we will calculate premium for unpaid interns, if an employer is engaged in unpaid intern and there is an injury, though the costs of that claim will be factored into an employer's claims experience as any other employee. The other question is the psychiatric support offered for secondary psychiatric conditions? The answer is yes, WorkCover will be offering support for secondary psychiatric conditions when they arise. It's important to note with secondary psychiatric conditions, we often find that the worker has previously had support at the instruction of their general practitioner or some other service that they've been engaged with. It's really a notification that that person is suffering from that injury, and we engage with it at that stage. But the answer is yes, if it comes up, we will certainly be offering psych treatment in the main until we can decide that secondary psychiatric condition.
So one of the questions we've also received is, so do all companies have to have a return to work coordinator? So that's the requirement that's set out in section 226 of the Act. In order for a company to determine if they are required to have one, they must meet the criteria that's set out in section 115 of the regulations to the Act. So the criteria is for an employer a criteria for an employer to appoint a rehab or return to work coordinator. They must meet the following: the employer who employs workers at a workplace in a high risk industry, that is, the wages of the employee in Queensland for the preceding financial year were more than 2,600 times the quotient, or otherwise the wages of the employer in Queensland for the preceding financial year were more than 5,200 times the quotient. Another question was, under section 224, how does WorkCover assess a worker's willingness to participate? So I'll just refresh. Section 224 is outlines when a worker's entitlement to remain in the accredited program continues. Look, this is determined on a case-by-case basis. Again, I refer you to the 5 subsections which are taken into account. when that determination is being made. Again, this is a reviewable decision, so linking that to another question, if we do cease the program, as a reasons for decision required to be provided to all parties? Yes, it is, on the basis that it is a reviewable decision. Another question we've received is, what is an accredited program? And if there's any examples of such. So an accredited return to work program is one that meets the criteria determined by the Office of Industrial Relations. They set out the criteria and the program is developed on that basis. And it is a copy of the draft program is to be submitted to the regulator for its approval. So I recommend you reach out to the Office of Industrial Relations in that regard. Another question with regards to rehabilitation and return to work are, who are the relevant parties that the insurer is to consult with in developing the plan? So that would be the insurer, the injured worker, and any persons that are treating the injured worker in developing that plan.
Okay, thanks, Amita. Another question I have here is, can the psych treatment be through the workplace EAP prior? With regards to the assistance that we propose to offer, we will obviously be sending that SMS and notifying the worker in a very short space of time with respect to us receiving the application. The worker has to accept the offer of treatment. They may have already had some EAP treatment prior. It's really, if they decide, it'll be a choice for the worker as to whether they want to offer any services we may be able to provide or whether they stay with the EAP provider. In relation to that, there's also a question, will we reimburse the cost of the EAP that the worker undertakes? The answer to that would be no. Another question we have that's come through is, does this mean that a generic medical certificate can be submitted instead of a workers' compensation certificate? WorkCover would always be looking for a WorkCover capacity certificate to determine the relationship of the injury. I'm assuming this question relates to a psych condition, and it may be that that is essentially a trigger for us to make some further inquiries, but we would certainly go back to looking for a capacity certificate.
Okay, we have had lots of questions regarding rehab and return to work coordinators. Many of those are similar, so we'll develop some FAQs and publish those to provide some answers to some of the questions that are coming through in the interest of providing you with some more concrete answers to your questions. So thank you again for joining us for today's session. Summary of the recording will be sent by email to everyone who registered for the session. If you've had any problems with sound or connection issues today, you can review the recording at your leisure. If you would like more information, you can contact your WorkCover Relationship Manager or call us. As I mentioned, FAQs will also be developed, which will assist you in answering some of your questions. We would also appreciate if you could take a few minutes to complete the short survey, which will come out with the recording email. Thanks for listening once again, and have a great day.